What's up, everybody? Welcome in to another episode here on The Lawyer You Know. We're going to be talking about the Delphi Richard Allen case that's going on right now behind closed doors with no cameras. We've got some people in the courtroom that are letting us know what happened, and we're going to talk about some of the alleged confessions, some of the conditions of Richard Allen that are starting to come out over the last couple of days that are some of the most shocking testimony and facts, and we'll kind of talk about why it's so important and those details are so important. But the main focus of today's video is going to be on the defense's second attempt to get the Odinism defense in and to get the third-party culprit defense, meaning pointing the finger at somebody else. It wasn't Richard Allen. It was somebody or multiple other people, which the judge would not let them argue at this point, which is kind of wild to start with. But now they say even more evidence has come out during trial, and they cite it in their motion. We're going to read that motion together. We're going to see what that new evidence is and see where we think this should go. And of course, what we think will actually happen in this case. Thanks for watching another episode of The Lawyer You Know. If you enjoy, just kidding. I played the outro on accident. So we're not done yet. We're not done yet. We've actually just begun. So hit the like button. Hit the like button for the outro. You guys got a little sneak peek of the outro that's coming later. But I'm going to start with the Odinism and the third-party culprit stuff, and then we'll talk about the conditions and the confessions and the interrogations at the end, because it kind of plays together in how this case is being presented and what the jury is seeing. And no matter how everything seems stacked against Richard Allen at this point, the stuff that is objective, right? Like a video of this interrogation in the beginning of the case where he denies, from all accounts, does not look like a guilty man as he sits there in the chair. We don't always know that, right? Guilty people don't always look the same. But that objective evidence where you can talk about it, you can try to spin it all you want, but they get to watch, the jury gets to watch with their own eyes how the cops treat Richard Allen, how Richard Allen treats the cops, how the cops treat Richard Allen's wife, a man presumed innocent, but you can tell they don't care about that. They don't think about that. And in the prison system, as he sat there as an innocent man, we're going to get to that at the end. But I want to start with this motion, which I was tagged in Matt Blanc Inc.'s Twitter post. And this is kind of the cleanest, easiest version. I got it. I don't have these documents myself. I just got it kind of this afternoon. It's been a crazy day dealing with all sorts of things, work and not work related, but we're here. We've got something to read it on where we can all see it and follow it together, and we can give some analysis here. Here we go. The accused's second motion to admit evidence of Odinism / Norse paganism / ritualistic killing, and also motion to admit evidence concerning Elvis Fields and Brad Holder as third-party suspects. So this is kind of multiple parts to this, but they've already attempted this once, and we looked at it together, and this was kind of a mind-blowing thing when it first happened. I remember when we talked about it, everybody was like, holy crap, this is wild. If anybody's asking what Odinism is, the only thing I know about Odinism is, yes, Sleuthy said you know where to find the PDFs. I'm assuming you mean you would send me them. I'm sure you would send me them, and I appreciate it so much. Honestly, I didn't even have time to like fully go through that process like I normally do. Somebody tagged me in this. I saw it. I was like, holy crap. You know, mine feels like it's blowing again. But in the future, I will reach out to you. And I appreciate everything you've done on this case, and always in the comments and doing anything you can to help in the cases that you're following. So Odinism, my only experience with Odinism is literally, and I don't mean this as a joke, like it is literally the Viking shows, right? The Viking shows and the Last Kingdom, and they worship Odin. Okay, that's really all I know. I guess there might be some like white supremacy stuff to it. I don't know like what Odinists believe today, but the only thing I know is based on the experts that the defense has, there are some like sacrificial elements to it, and that's the connection they are trying to give. Okay, and what's interesting about this, right, is the Odinism part of it doesn't necessarily mean it wasn't Richard Allen. Now, I think his defense attorneys think that if they can prove the Odinism is a part, then they can prove it's not Richard Allen because some of the third-party suspects are maybe involved in Odinism. So to me, it's kind of like a two-step process, which is even more interesting as to why the judge at first would not let this in. As a criminal defense attorney on my side, okay, I don't know who did this, right? I don't know if it was Richard Allen. I don't know if it wasn't Richard Allen. So we'll start with that, right? But who did it is kind of a secondary question to, can the state actually prove it? And part of the state actually proving it is, this is the guy who did it, meaning nobody else did it. So if the defense has evidence that somebody else did it, they should generally be allowed to present that evidence. Now, are they allowed to say it was a man on the moon that did this? Usually not. Usually it has to be a reasonable inference from the evidence that you have to be able to point the finger at somebody else. But at the same time, some judges, having kind of a more liberal leeway in protecting defendants' rights, will say, if you want to say it was the man on the moon, go ahead and make the argument that it was the man on the moon. And from my perspective, jurors aren't stupid. They're not going to be like, oh yeah, this must have been the man on the moon. Let's say this guy's not guilty. So from the perspective of not allowing this stuff in, blocking this stuff from coming in, from my perspective, I just don't get it. Like, what are we scared of? I guess they're saying they're scared that the defense attorneys are going to use smoke and mirrors to trick the jury. But if you have enough evidence and you have a guy confessing, right, you should be pretty confident in your case. If you have all of the cards and you have the decision to bring a case or not bring a case, and you choose to bring a case, meaning you're confident you can prove it beyond a reasonable doubt, then you should be able to disprove that it was anybody else, because it was Richard Allen and only his bullet was found there and only he confessed. Sure, talk about Elvis and Brad all you want. At the end of the day, they didn't confess. Nothing connects them to the crime scene. This is just pure conjecture for the defense. That's what the state should argue. And we see that happen in trials all the time. It's just, it's not a good feeling for me, right? If you want to call people conspiracy theorists that think the Odinist stuff is legit, or think all of this, the state is stepping on Richard Allen's rights, if you want to call that conspiracy theorists and stuff, fine, but this doesn't help. Closing the doors, no cameras, gag orders, and then not allowing the defense to make very normal, I shouldn't say normal arguments, like the Odinism stuff is far from normal, but third-party culprit defense, like that's very normal if the defense has reasonable evidence that they can point to this, which we're going to read through this motion now. And if you can't see it, somebody said it's small. I'm going to read every word, so don't worry about that. But let's get into, we already knew a lot of what they had before with the other files, with the police officer that investigated it the first time around and found a lot of this information and a lot of connection on social media to these guys in the case. Well, even more has come out since then, and that's what we're going to read through in this motion today. Comes now the accused, Richard Allen, by and through counsel, and moves this court to admit certain evidence that this court thus far has prevented the defense from presenting to the jury, pursuant to its September 4th, 2024 order granting the state of Indiana April 29, 2024 motion in limine. In support of said motion, the defense states as follows. On October 23rd, 2024, so that's in trial, right? That's a week ago. Trial is going. The defense has previously filed this motion to admit evidence of Odinism / Norse paganism ritualistic killing. Since that motion was filed, additional evidence has been elicited through testimony. Actually, what we read was not this first motion. It was like the Frank's motion, but same stuff. Since that motion was filed, additional evidence has been elicited through testimony and other evidence that further opened the door to the admission of Odinism, Norse paganism / ritualistic killing. So I want to pause there. If you remember, if any of you guys watched, was it just Monday, 2 days ago, was Andrew's podcast? John's sitting back there. So if I'm talking to somebody in here, that's what it is. I can't believe it was only 2 days ago. It seems like a lot longer ago than that. But just a couple days ago, Andrea and I were talking about this, and she said in Indiana, the judge will take this up again and the defense can ask for it again. So she was a fortune teller on Monday, because she even said, it seems like it's going in that direction. And here we go. We get the defense's second request. And not only are they just requesting it again, because she said at certain times, like, there may be enough evidence. You can't mention it in opening, but if you ask me again later, maybe I'll let you talk about it in the trial, right? Well, they're doing that, but they're also saying more evidence has come out in trial to add to everything they had pre-trial. Since October 23rd, the motion was filed. Additional evidence has been elicited through testimony and other evidence that opened the door for the defense to bring in evidence of third-party suspects Elvis Fields and Brad Holder were involved in the killing of the victims. Additional evidence admitted during trial that supports the introduction of Odinism / Norse paganism / ritualistic killing evidence. So this is evidence we didn't know about before. Maybe the defense did know some, didn't know how it was going to come out. But now that it's come before the jury, it's incredibly important because the judge can do a lot of things, and a lot of things happen, especially in civil cases where, okay, this side, you're not going to talk about this. And because you're not going to talk about this, you're not going to talk about that either. So if you don't talk about that, they can't talk about this. But if you talk about this, they can talk about that. So that may be confusing, but a judge can do a lot of carving out prior to trial. But once something becomes an issue before the jury and the jury hears something and they're considering something, now we've got a different ballgame. Now we got to make sure it's fair, it's complete, the jury is not being misled. All of that is incredibly important once evidence starts coming out before the jury. David Reese says, this version of Odinism is a group of white supremacists. Traditional Odinists don't practice human sacrifice. Okay, that's a great explanation. Thank you. I don't know the answer to this. I don't know if David's right or wrong. I've heard different explanation of it. And again, all I know of is the Viking, which makes me no expert because those are all fake shows. So I admit that there. On Wednesday, October 23rd, forensic pathologist Core testified that possibly 2, possibly 3, possibly 4 instruments were used to cut Abby and Libby. That in his autopsy report, Dr. Core believed that some cuts may have involved the use of a serrated instrument, other cuts may have involved the use of a non-serrated instrument, providing the possibility that more than one person was involved in these killings. So that we can track, these arguments are somewhat going to stack on top of each other, which is different than inference stacking. You're not allowed to inference stack, which we can talk about another time, but you can stack evidence on top of each other to get to a certain point. He is saying at this point, evidence has come before the jury that it's possible this was more than one person. Now, it seems like a lot of this stuff came out on cross, but once evidence comes before the jury that this could have been more than one person, and the defense has a group of 2 people that they think committed this crime, now we're starting to track, and they should be able to provide the jury with why they think it was 2 people. And there's going to be more evidence here, but the first one they say is multiple types of blades. That's why they think it was 2 people. That's number one. So as we think of all these different reasons they're going to argue it's 2 people, they're saying that's enough evidence, Judge, for us to get to these are the 2 people who did it. We actually know, and here's why. And they should be able to put that in front of the juries with their argument. That in his autopsy report, Dr. Core believed that some cuts may have involved, I already read that. During his testimony, Dr. Core backtracked somewhat, but still did not exclude the possibility that the injuries to Abby and Libby were caused by both a serrated and non-serrated instrument. Also, since the trial began, the prosecution admitted certain crime scene photographs into evidence, including photographs of the crime scene in which the sticks on the girls were clearly visible to the jury, allowing the defense to ask questions concerning the sticks on the girls. Any competent trial lawyer would ask a variety of questions concerning the unusual way that the sticks were placed on the victims, and it would be ineffective for the trial lawyer to not ask questions concerning the sticks placed on the victims. On Saturday, October 25th, because yes, they're having court on Saturday, Lieutenant Jerry Holman from the Indiana State Police testified to the following. On cross-examination, Lieutenant Holman testified that it was his belief that the sticks branches found on the girls were used by the killer to conceal their bodies. And we heard from Andrea, based on the way the pictures looked to her on our podcast again, she said, doesn't look at all like how you would try to conceal somebody. There's much better places and much better shrubbery to use to try and cover up or conceal a body than what they did with these stick placements. That's her perception. Maybe a juror would see it differently, but very clear, Holman testified to that effect. On redirect, meaning the prosecutor asking him questions, McClellan asked Holman if another reason the sticks/branches were found on the girls was something called an undoing. Lieutenant Holman responded, yes. Through Dr. Core's testimony, it was determined that it is feasible that multiple people using multiple knives supported the defense's theory that Odinist Norse pagans were involved in this case. As Dr. Perlmutter testified on August 1st, 2024. So whenever he mentions August or something before, these are different hearings they've had that, again, no cameras were there, but hearings that they've had where they've testified about this stuff, and we've gotten more background on Odinism in this defense. Knives are a classic sign of Odinist Norse paganism culture, and that knives are classically used in ritualistic killings. So here's what I'll say about that. I think that is a point to be made and something you can stack on, but nowhere near dispositive, right? That, well, if it's a knife case, then it must be an Odinism or Norse killing case. That would not be enough, right, on its own. So it is something we'll consider, but it's definitely not enough on its own to say that, oh yeah, that must be what's going on. Paragraph 10, Dr. Kaur's testimony revealed that perhaps as many as 4 knives were used, and at least one of those knives may have been serrated, supporting the defense's belief that multiple Norse pagan Odinists using multiple knives were involved in this case. Furthermore, upon viewing the crime scene photographs that have been admitted into evidence, because now they're in evidence before the jury, there are no obvious drag marks to the naked eye, nor were there any police reports or charts that show drag marks at the crime scene. Even blood spatter expert Pat Cicero admitted that he could observe no drag marks on the crime scene photographs that he reviewed. Why is this important? Can anybody tell me why this is important before we start going into and the defense explaining this, right? As I explained at the beginning, there's going to be a bunch of stuff in this that are going to be facts stacking up and walking us down the line of this was 2 or more people, meaning it wasn't just Richard Allen. And if they're saying he acted alone, then it wasn't Richard Allen at all, is what the defense is going to try to argue. So no drag marks on the bodies where they laid. Everybody seems to admit at this point that this is not where the actual killing took place, but they were taken and placed there. And if there's no drag marks, that means either 2 or more people picked them up and put them there, or one person was able to pick up the body and move it on his own. Not dispositive, but I do think tending to prove, right? Relevance is, does it tend to prove or disprove any material fact in the case? That's what relevant evidence is. It has to be something that tends to prove or disprove a fact in the case. Not impossible, right? It doesn't mean it's impossible for one person to have committed this. So I don't want to get it twisted and say all of this evidence absolutely guarantee proves that Richard Allen is innocent. That is not at all what I'm saying. What we're looking at here is this relevant enough? Does this evidence tend to prove or infer something that the defense wants to argue as a third-party culprit defense? And if so, they should be able to put on that defense. That's the question we're asking. It's a much lower bar than proving this case beyond a reasonable doubt. The fact that there is no evidence of drag marks supports that more than one person was involved in this case, including 2 or more people needed to lift Liberty German's body, explaining why there was no drag marks from where she was killed to where she ultimately was found, supporting the possibility that multiple Norse paganists Odinists were present and participating in the case. As it relates to Lieutenant Holman's testimony, when Holman answered yes when asked if another theory of why the sticks were on the bodies was because of something called an undoing, his testimony is yet another reason provided by the state of Indiana as to why the sticks are on the girls. So that is true. So the state has elicited now 2 potential opportunities. I shouldn't say opportunities, 2 potential explanations as to why the sticks were placed on the girls at their final resting place. That'll be important later. The questioning of the prosecution and the answer of Lieutenant Holman pertain to yet another explanation and undoing as to why the sticks were found on the girls, and therefore the prosecution opened the door to the defense's alternative theory as to why the sticks were found on the girls. So basically what the defense is saying, I don't believe, I could be wrong, and we'll keep reading and you guys can tell me how you read this, but I don't believe they're saying the undoing specifically means Odinism, but they're saying if you're providing multiple different reasons for the sticks to be there, we should be able to provide different reasons why we think the sticks are going to be there. And the jury can compare our reasoning with your reasoning and make a decision, because the jury can make decisions based on the evidence, the lack of evidence, or conflicts in the evidence. And these are conflicts in the evidence that are so important. People are saying the crime scene was within 6 feet or so. Okay. Still, there would be drag marks. Brianna said, what about a wheelbarrow to move the bodies? I think, could be wrong. And again, it wasn't the best investigation. And we know it took 7 years or something for them to get this case to trial. So there was a lot going on, a lot of delays in making arrests and things like that. But I don't remember them saying, oh, these are clearly wheelbarrow tracks, which I feel like you would be able to see if that happened, but it could be. Absolutely could be. And this is something the jury should be able to discuss, right? As different options. Maybe he carried him alone. Maybe it was multiple people. Maybe it was a wheelbarrow. What does the evidence actually point us to? And the defense thinks they have enough evidence to make this argument. I was shocked to find out the trial that R.A. only confessed after being subjected to solitary confinement for 5 months. I believe it was longer than that. And we're going to talk about some of that at the end of the video. So if there were, wheelbarrow wheel tracks or drag marks or anything like that, I think the state would have presented it. Not saying they had to, but they should have, right? They should have, because they need to prove this case beyond a reasonable doubt. And if you can look at the pictures and another juror says there's no wheelbarrow markings here, there's no drag marks, there's nothing. The only explanation is that they were lifted up and put down. Now, doesn't mean it's impossible that one person did this. Okay. 15. The defense has its own theory as to why the sticks are on the girls, and Richard Allen has a Sixth Amendment right to provide that theory to rebut the state of Indiana's theories, including the prosecution's latest theory that the sticks were related to an undoing. Additionally, blood spatter expert Pat Cicero opined that the prosecution led the jury to believe through questioning that Liberty German was moved to her final resting place to conceal the body. So that seemingly, again, we're not in there, so I'm taking the defense attorney's word here, but it seems like the blood spatter expert agreed with and even testified to the fact that the body was moved to their final resting place. So if it was moved and there is no drag marks, how was it moved? That's a question that the defense finds very important. The prosecution's line of questioning of Pat Cicero was pursued by the prosecution on direct examination and opened the door to the defense offering alternative theories as to why the body was placed in its final resting place and why the sticks were placed on the girls. The defense's theory that Liberty German and Abigail Williams' final resting place was related to Norse paganism / Odinism and ritualistic killings. So here's what else I'll say, and probably what Judge Gohl, part of what she's going to use is motive is not something that the state has to prove beyond a reasonable doubt. And you guys are just fighting motive. And while she's right, fighting motive or saying no motive or lack of motive has won many a criminal defense case. If it just makes no sense that this person would never do it, and you can point to somebody that has more of a motive, it should at least be argued in front of the jury. The jury doesn't have to believe it. The jury doesn't have to buy it. The jury is the ultimate decision maker. But to not allow them to even make these arguments, it just seems un-American to me, that you're not even allowed to put up your defense. Richard Allen has it because if the defense, this opens up to, if it's too weird and unbelievable and too big of a conspiracy theory, well, then we're not even going to let them argue it to a jury. And it's like, well, the way the world is going today, I don't know what to believe. I don't know what to believe. I don't know what to think. And from my perspective, if we're going to not allow arguments because a judge thinks that it's too weird of a conspiracy theory, that doesn't make me feel real good. If the jury thinks it and the jury's like, no way too big of a conspiracy theory, throw it away. Well, that's the jury's job. The defense believes that both Liberty and Abigail's bodies were placed there because of the desire of the Odinists to pose the body and form the sticks on the body in an arrangement for reasons only understood by the person / people that ended the victims' lives. Dr. P said in his testimony that has testified as to how the sticks would only have meaning to the people who were involved in this case. And again, he testified at a hearing, not at trial. This is the Dr. P stuff is not testimony from the trial. Additionally, the defense expert, Dr. P, indicated in August 1st, 2024 hearing that the arrangement of the sticks was not an undoing, as an undoing is typically an attempt by the killer or killers to provide dignity to the victims. Hallmark of an undoing is closing of the eyes and mouth of the victims. In this case, the girls' mouths and eyes were open, and one victim was displayed without clothes in an undignified manner. This would be inconsistent with an undoing. The defense should have the opportunity to explain what it believes is an undoing and how the crime scene does not exhibit an undoing. Now that, again, I agree with 100%. If you're going to have somebody testify this might have been an undoing, that's why the sticks were there like that, and you have evidence to say this was absolutely not an undoing, explain to me, like I'm 5, how that's not relevant. Like you're discrediting the state's case, which is, from my perspective, part of your job as a criminal defense attorney. Evidence introduced before and during trial that supports the introduction of third-party subjects Elvis Fields and Brad Holder. On Saturday, October 25th, 2024, during the trial, Lieutenant Holman was asked a question about how many people were involved in this case. Holman offered only one person was involved in this case. After offering that only one person was involved in the killings, Holman offered the following. As part of his reasoning for believing that only one person was involved, based on his training and experience, when more than one person is involved in a crime, there is often a point in time when one of the participants will discuss the crime or reveal the crime, whereas when it is only one person, it is much easier to contain that secret. That was Lieutenant Holman's theory that supported his belief that only one person committed this crime. Since September 18, 2023, the defense has consistently maintained that evidence supports that Elvis was a participant in the crime, along with Brad Holder and others. According to Holman's theory, as testified under oath October 25, 2024, if it is true that Elvis and Brad were both involved in the crime, then it is likely that one of them will have admitted to being involved in the crime or providing incriminating statements concerning being at the murders. Evidence exists that supports the defendant's contention that multiple people were involved in the crime and supports Lieutenant Holman's theory that if multiple people are involved in the crime, at least one of them will reveal the crime to others. For example, blood spatter expert Pat Cicero testified that it is possible that both girls' lives were ended at the same time. That's another stack, right? Multiple blades and weapons not dragged, and that potentially the deaths happened at the same time. How would one person do this with multiple blades at the same time? It makes no sense. Which would indicate that more than one person was involved in the crime. Additionally, Pat Cicero also admitted that one explanation for Abigail having no blood on her hands is that while her neck was being cut, someone else was holding her hands down. Okay. And again, these things are kind of like, okay, probably, probable, likely, but all enough to be able to make the argument. That's all they're asking for, is let us make the argument. Let the jury make the decision. That's all it is. Not saying, I mean, they would like to throw the case out, obviously, over this, but at this point, what we're asking for is just let the jury consider this stuff. Let the jury consider this stuff. Law enforcement conducting the investigation into these crimes have interviewed one suspect, Elvis Fields, who asked inculpating questions to the state trooper and has connections to those who have incriminating evidence on their social media, as well as direct connections to one of the victims. So the incriminating stuff on the social media would relate back to Holman saying somebody would spill their guts at some point. Andrea Burkhart. Somebody can spell it in the chat, or you can go to our podcast that was 2 days ago on Monday. Check out that video, and it has all of our information linked in there. Okay. Brad Holder's first alibi. Therefore, evidence exists that multiple people were involved in this crime, rendering all purported alibis as suspect due to the ability for the ringleader to claim an alibi while others are doing his bidding in terms of abducting the victims. Brad Holder's first alibi, for example, would allow him to be at Delphi no later than 2:30, perhaps earlier, while Elvis and others abducted the victims and held them awaiting Holder. So again, does some of the defense theories have holes? Yes. Oh, of course he has an alibi because somebody else was doing his bidding. I mean, from my perspective, if the state was going to argue that about it, the criminal defendant, we'd be like, it would be stronger evidence if the criminal defendant that's on trial was actually there at the time of the crime. But if you can prove that somebody did it in his place and gave him an alibi, sure, that's possible. But again, we're not talking about proving this case beyond a reasonable doubt. In the defense, I should say. We're not talking about proving the defense beyond a reasonable doubt. In 2018, law enforcement pulled Elvis Fields in for questioning at the Rushville Police Department. At the end of the interview, they took Elvis's DNA and then explained to Elvis their reason for taking his DNA. At the conclusion of the interview, Trooper Kevin Murphy drove Elvis back to his home. After the trooper dropped Elvis off, Elvis walked toward his home, then turned around, approached Kevin Murphy's car. After getting close to Trooper Murphy's vehicle, Elvis asked Trooper Murphy, if my spit is found on one of the girls, but I have an explanation for it, would I still be in trouble? Okay. Alarm bells should be going off when you hear things like this. This is not the first time I've heard this. I don't think he's referencing specifically evidence that came out of trial. I think this is stuff they had before. Because it didn't say, Lieutenant Holder said this in trial, but a very weird thing to say. And seems like said by somebody who probably spit on their bodies. Also, seems like, if I was playing devil's advocate here, seems like something somebody would say, I didn't actually do this, but I did spit on them. Right? You can argue that too. Point is, very weird, and definitely something that the defense should be able to tell the jury, because you better believe if Richard Allen would have said anything to that effect, the jury would have heard it. But instead, during his interrogation, he vehemently denied before being thrown in solitary confinement. But that is a very weird and creepy statement. DNA analyst Stacy Bozanovsky testified at the end of her cross-examination on October 28, 2024, that a person's spit can be analyzed for DNA. Additionally, evidence exists that supports that Elvis Fields was mimicking Brad Holder, who lived 125 miles away and should have no ties to Elvis Fields' Facebook posts, or that Brad Holder was mimicking Elvis Fields' Facebook posts before the victims were abducted. So all this really tells me is they feel like they can prove that they're connected. Elvis Fields has claimed under oath that Brad Holder was actually mimicking Facebook posts that Elvis Fields had posted. Brad Holder's son, Logan, was dating Abby Williams, and Brad Holder had evidence that exhibited Holder's knowledge of the crime scene on his social media that no one else should know. Meanwhile, 125 miles away, Elvis Fields, who seemingly would have no reason to know Brad Holder even existed, A, followed Brad Holder on Facebook, mimicking his posts, or vice versa. B, was making statements that inculpate him at the as to the being involved in this case, including expectation of the possibility that Elvis's spit might be found on the girls. I mean, that's wild, right? Not close together, 125 miles apart. And we have these connections with son dating one of the victims at some point. These two being connected, Facebook posts mimicking each other, them all talking about it. Sounds kind of like what Holman said. If multiple people are involved, maybe at some point they'll let something slip. Were they letting things slip? Yeah, and there we go. They had ultimately revealed the crime. Additionally, evidence from Brad Holder's social media supported the concept that others assisted him in committing the crime and moving the bodies, as Holder posted a meme on his Facebook page a few days after their lives were ended, and the theme and words from the meme have become more important due to the testimony that has been elicited during trial. And it's really important for the defense to keep saying, if you think they're being repetitive about saying testimony elicited at the time of the trial, it's because they're saying, Judge, you need to reconsider your prior ruling because we know more now. And that's important. And we're not saying they are saying you were wrong before, but from the judge's perspective, judges don't like to admit being wrong before. So it's like, I was right at the time, but now that there's more evidence, I'll change my decision. According to blood spatter expert Pat Cicero, Libby German's 200-pound body was in fact moved from one location to another. 200 pounds of dead weight, I think, can be moved by one person. I know that it can be moved by one person. It's obviously easier moved by more than one person. So again, tending to prove a certain fact. I think it could tend to prove it's more likely that it was two people, and maybe there's some reasonable doubt there. But again, I do not think this makes it an impossibility that it was one person. Also, pursuant to the blood spatter expert, there were no drag marks that could be seen in the crime photos. Therefore, evidence supports that Libby's body was moved from one location to another and that two or more people would have been needed to carry the body since no drag marks existed. Certainly, it would be highly unlikely that one man could accomplish that task. I tend to disagree. I'm not the strongest, biggest guy in the world, but I will say I could carry a 200-pound body if I really needed to. I would hope that I wouldn't, but I think I could based on, some workouts that maybe have similar movements to them. And Sleuthy brings up a good point. 5'4", 150-pound man. And here's the better thing, I will say. The jury's looking at him in the courtroom. All reports are that he's much sicklier and skinnier looking now than he was at the time of the crime. Which, if the state, and to make the state make that argument, right, and maybe they'll say something like Sleuthy said, oh, he was much bigger back then. Does that almost kind of help the defense? Yeah, you're right. He's much skinnier and unhealthy and sickly looking now because of what you guys have done to him while he's been presumed innocent. Wife, you should go and let them know what you saw that day. Richard, I don't know. Wife, there's nothing to worry about. What could go wrong? So many things from this case doesn't feel right, and it's a dang shame because these girls deserve true justice. I mean, that's the saddest part about all of this, right? Is what happened to these two little girls, and now the way it's playing out, if it was Richard Allen, to me, they have slopped doubt all over this case with the investigation and how they've prosecuted it and how they're doing this trial. That's what really pisses me off when we think about the victims in this case. As a Norwegian, it's sad to see an important part of our past and culture mentioned in the context of such a horrible crime. Yeah, Ninny, and here's what I'll say, right? And this might not be that helpful to you, but bad people can twist and maneuver and use things that are either good or indifferent or not bad on their own, or could be seen as culture or tradition. They can take it and twist it, and the media will, do one thing or another to make everybody ever associated with that seem bad. And it's not always the case. So this is an isolated thing with this case that it's coming out about this. And, I hope people don't connect it back to all Norwegians like yourself. And we would never do that, obviously. And that would be foolish to do so. He may be not guilty, but blaming pagans is so 1600. Honestly, I think what they're doing, here's what would be my take on it, is more than just blaming all pagans or blaming all Odinists or whatever, Norwegians, whatever it may be. What I think they're saying is we think it's these two guys, and we think one of the reasons we know and what their motive is based on how they set up the crime scene, which is Odinism, and therefore it connects and locks in these two guys or these two or more guys, this group of people. That's what I think they're doing. I don't think they're trying to paint with broad strokes here. Discrediting the state's case. Didn't you hear? Discrediting the state's case isn't allowed. The judge won't allow them to attack witness credibility. And Carazola, I do not understand how this, if this is actually the case, and I have heard rumblings of things like this. I know you're being sarcastic, but I've heard rumblings of witness credibility or inconsistent statements or potential lies or impeachment is not relevant. I'm like, that's like the number one most relevant thing, bias and impeachment on cross-examination. It would be so hard to sit down in your chair as a defense attorney when you hear a judge say things like this. Julie, Zach Anderson was not allowed third-party defense either, but Denny rule fails if you apply it to Zach. Seems like burden shifting to me. The prison Allen was held has been sued for Eighth Amendment violations. Can't imagine why. I've also heard it's getting shut down. I don't know. Yeah, I mean, there are definitely rules. You can't just point the finger at random people. There's got to be evidence that you can infer from, and different states have different burdens that you have to do to get there. Are the courts this secretive or just this judge? I want to say just this judge. I shouldn't say just. Some courts and judges are, most are not in our country, and I think we need to keep going more in that direction and not the direction of this court. Thank you, Susan, for gifting a membership. Let's get back to the document here. Where were we? All right. I think additionally, the evidence previously provided to this court in the Franks memo, as well as admitted into evidence on August 1st, provided proof that Elvis Fields did not have an alibi that could be substantiated. But quite the opposite. Elvis Fields' alibi is sketchy, and his version of his whereabouts on February 13, 2017 runs counter to those who allegedly were with him on that day. In other words, no one could keep their story straight about Elvis's whereabouts on February 13, 2017. So clearly they would want to point the finger at him, talk about how he's got a sketchy alibi, things like that. And there will be limits as to how much you can really put somebody else on trial. But to just make these arguments, to me, seems like there's enough here. Holman's October 26th testimony, now we're back at trial testimony, leaves the jury under the mistaken belief that no evidence exists, that multiple persons were involved in this case, and that no other suspects have made any statements that inculpates them in the crimes, thus supporting Lieutenant Holman's theory that when multiple people are involved in a crime, at least one of them will ultimately reveal the crime. So again, this would be an example of Holman said something. Holman said something to the jury. Holman explained it as a fact to the jury, and now it's evidence because his testimony is evidence. We want to present evidence in our case, Judge, which the defense's case is a response to the state's case and a presentation of our case. We want to respond to Holman's testimony that is now evidence in front of this jury that there's no evidence that it was more than one person, that there was no other suspects that made inculpating statements. And I don't know the totality of his testimony, but if he was saying, yeah, I interviewed Elvis, if they were even allowed to talk about it, but he wasn't a suspect, then again, that would be contradicting something that the state presented as evidence. At the time of his October 26, 2024 testimony, Lieutenant Holman was fully aware that evidence existed that Elvis Fields made inculpatory statements concerning being present at the scene and at the time that the victims were killed. At the time of his October 26, 2024 testimony, Holman was fully aware that the evidence existed that Elvis Fields of Rushville, Indiana had a connection with Brad Holder from Logansport Indiana, and in fact said evidence produced from law enforcement investigation showed that Brad Holder and Elvis were mimicking one another on Facebook. At the time of his trial testimony, Holman was fully aware that evidence existed. Brad Holder's son, Logan, dated Abby Williams. So he's saying none of this is a surprise. He knew about all this. We need to present this to the jury, period. End of story. At the time of his trial testimony, Holman was fully aware Brad Holder had evidence on his social media consistent with signatures left behind at the crime scene, including a mimicked crime scene photograph that looked eerily similar to the way the bodies were posed on the ground of the woods, and photographs of sticks laid. We're going to jump to the other 2 pages. Laid down on the ground in a similar pattern of sticks found on Abby's body in the form of hand-drawn pattern on the wrist of Brad Holder. Among other incriminating items, including a post about real friends helping move bodies. Is this dispositive? Does this mean beyond a reasonable doubt it was Brad Holder or Elvis? No, it does not mean that. But it sure as heck seems like enough to present to the jury to let them consider the contradictions in this evidence and the holes in this evidence. What's Richard Allen's motive, right? Juries are going to be asking themselves that question. What was his motive? I guessed, based on the summaries of the opening statements I heard, that he wanted to have his way with these girls before, he did this to them. That was his motive, I guess. A guy that's, I haven't heard that he's ever been convicted of any other crimes, worked at CVS. So if the jury's asking for motive, and you have some people that have a legitimate motive that you feel like you can present to them, I'm just not following why they would not be able to at least make some of these arguments to the jury. I'm not the smartest guy in the world, but usually I can see why judges and people make the arguments from both sides, and I'm really struggling to find the explanation on this one. At the time of his testimony, Holman was aware Odinist Norse paganists had been investigated and being involved in this case. So other officers actually looked into this, and we heard more, or we read more about this in the prior motion that we read, way back when. But this wasn't something the defense just made up. It's something that had some legitimate connections to the case, even if it didn't end up resulting in an arrest. And just okay, in case anybody doesn't know this. And this is one of the reasons that cops don't like to make everybody a suspect and bring a bunch of different people in and interrogate them and say, you did it, you did it, you did it. Because we as the defense attorneys can get a lot of those files. They're public record. They're part of the case file. Unless they hide them and put them under a different case number and give them somewhere else like they did in Alec Baldwin's case. But if we get that and we're like, oh, you told Mr. Johnson you knew he did it. You told Mr. Jones you knew he did it. And then you ended up arresting Mr. Smith. Well, guess who we think did it? Mr. Johnson and Mr. Jones. So we're going to tell the jury it was Mr. Johnson and Mr. Jones. And you know what evidence we're going to use? The evidence you had against them. That happens all the time. All the time. At the time of his testimony, Holman was aware that both Brad Holder and Elvis Fields possessed knives and that Brad Holder used knives as part of Odinism religion. At the time of his testimony, Holman was aware, or should have been aware, that Holder possessed a .40 caliber handgun. And again, they're saying the bullet matches Richard Allen's, but they're going to argue that's kind of junk science. You can't really know because it wasn't actually fired, and the markings, the way they had to do if you listen to Andrea explain it, she'd do a much better job, but the expert could not recreate the markings on the firearm. So maybe it's just as likely it was from Holder's gun as it was from Allen's gun. It's an argument the defense wants to make. At the time of his testimony, Lieutenant Holman was aware, or should have been aware, that Brad Holder's .40 caliber was never collected, tested, fired, or compared to the bullet allegedly found at the crime scene. Yeah. So they didn't even do the investigation, which again becomes lack of investigation, bad police work, and reasonable doubt. Reasonable doubt. That's what the defense is arguing at the end of the day. Therefore, the jury has been misled into believing that law enforcement... Before I read this, so I see some people posting about it's kind of impossible for Richard Allen based on his stature and size. Guess what? If that is an impossibility, they are still able to argue that. That's not something that's going to be blocked from the defense. They are still going to be able to argue that multiple people did this, They're still going to be able to argue it wasn't just Richard Allen, and they can argue a lot of the things that are in this motion. I guess unless the judge said no, I'd be shocked if she said that they can't argue that it was more than one person, that he couldn't have lifted her, that he couldn't have committed these crimes with multiple blades at the same time. I would think, I should say, I shouldn't be so confident here because this judge surprises me, but they should still be able to make those arguments. Specifically, what they can't do is make the Odinism connection and specifically point the finger and put forth evidence that this was Holder or Elvis. They could still make some of those arguments without using these specifics and, again, bringing evidence that it was other people. Therefore, the jury has been misled into believing that law enforcement's only available evidence only supports that only one person was involved in the crime. When Lieutenant Holman's own words on the stand, evidence from law enforcement investigation, and trial testimony from Dr. Core, Pat Cicero, and Lieutenant Jerry Holman would support the defense theory that multiple people were involved in the crimes. This is true because Elvis Fields has provided inculpatory statements, had a social media connection with Holder. Holman has indicated that when multiple people are involved in a crime, it's experienced that one of the participants will ultimately reveal the secret of the crime. It is also true that because substantial amount of evidence supports that Brad Holder's social media contained words and images that are consistent with the crime scene and also consistent with creating or showcasing an alibi at 2 a.m. on February 14, 2017, when for the only time in his life, he claimed in a Facebook post that he was at the gym, as Holder stated under oath in a deposition. Holder's social media is also consistent with others being involved as assisting him with moving the bodies. Richard Allen possesses a Sixth Amendment right to rebut Lieutenant Holman's theory on one man and only one man was involved in this case, especially when Lieutenant Holman's reasoning for believing that only one man was involved in the murders is debunked by the evidence detailed herein, including Elvis Fields' inculpatory statements that supports Lieutenant Holman's belief that when multiple people are involved in a crime, ultimately one person will spill the beans. Additionally, as previously detailed, Richard Allen possessed a Sixth Amendment right to present evidence that those involved in Norse paganism/Odinism were involved in this case and posed the girls and placed the sticks on the girls in certain arrangements for reasons that are very personal to the person that committed the crime. Defendant files this motion currently in part for purposes of a ruling in anticipation of the need to contact our witnesses if the court reverses its ruling. If it isn't Richard Allen, has the prosecution ruined any chance of prosecuting the real culprit? That person's defense would be on RA for them. I shouldn't say yes, emphatically 100%, but practically speaking, yes, they've made it very, very difficult now to prosecute anybody else because of all the evidence they have of Richard Allen. And you can imagine how if I'm representing Brad Holder and let's say they try to come after him, I'm going to say, we got this guy, Richard Allen, who confessed to the crime. Prosecute him. My guy didn't do it. That guy admitted that he did it. And then you got to now go prove it was a false confession as the state, and just your job becomes a lot more difficult. Amanda, does a juror have any recourse if they convict someone without hearing this? I'd be beyond upset. Thank you. No. Those are legal decisions. And again, that's what the appellate courts are for. If the judge screwed it up, we get rid of that verdict and do this trial all over again with a new jury. So if the jury really did make a wrong decision based on the evidence, that it's not going to be on their conscience because our appellate system should fix that theoretically. Fancy, as someone of Norse heritage, these Odinism claims make me so angry. Odinism, or Asatru, is still the state religion on Iceland, and it's not evil. And like I said before, this wouldn't be the first time that somebody took religion and twisted it for their evil ways. If that's what happened here, I don't know, right? I don't know, and I'm not saying that. All I'm saying is there seems to be more than enough here for the defense to be able to present this argument to the jury. The jury should be able to consider it and make their decision. Even knowing all this, is it still proven around to be beyond a reasonable doubt that Richard Allen committed these crimes? Chat is divided, people are saying. That doesn't bother me if the chat's divided, right? It doesn't bother me if some people think he did do it, some people think he didn't do it. But even if you think he did do it, why do you think they shouldn't be able to present a defense that they have other people that were posting things about it online? They're literally arguing that Richard Allen confessed and knew things that only the killer could know that other people couldn't know. Well, the defense is saying there's another guy, Brad Holder, who was making statements and comments on social media that only the killer could know. The DNA spitting stuff is very weird. Richard Allen has no connection to the girls. Brad Holder has a connection to the victims through his son. I find it interesting. I really do. make sure you guys hit the like button. We're going to go through now some of his, just kind of quickly here at the end of the video, some of the issues in this case as well that the jury's hearing. Make sure you subscribe as well if you guys have not already. We're going to continue to do this. I'm trying to set up other podcasts in the future with other people that are in the courtroom because you guys seem to really want that. So hopefully next Monday, we'll have another one. We'll see. We're working on it. I reached out to lawyer Lee, so I'm waiting for her to get back to me. And then maybe there will be more going in the future there, but she was the one most of you guys asked about when I had Andrea on. Okay, so just kind of quickly thinking about the interrogation and / the confession at different times. Initially, it seems like all reports were he didn't seem like he had a guilty conscience, was emphatically denying it. Even when they brought his wife in, yeah, he got agitated. If you start to figure out you're getting accused of a crime or getting arrested for something, maybe you'd get agitated too. But that the cops were getting in their face, yelling at him, and you were, seeing the real monsters that are cops, right? And that's more than just Andrea saying that. I've read multiple reports of things like that. And from my perspective, that's good for the jury to see that. And to see that even after all that in the interrogation, he didn't confess. He never really did anything to say he did it. In fact, he denied. Then 13 months, maximum security, solitary confinement, even time out of his cell was with walls and an open ceiling. And he starts washing his face with toilet water, wiping feces all over the place, including potentially eating some. And then he starts making some confessions. Some of his confessions don't even make sense. Some of his confessions are factually incorrect. Some of them, the state argues, is information that only the killer could know. So I think there are things the jury's going to have to weigh. Is this real? Is it not? Based on all those different contexts. And that's the jury's job. But what I'll say is, let's say the confession's real. Still, inexcusable treatment of a human being that is presumed innocent. Just think about this for a second, guys. Think about this. Before he confessed, let's just all agree, he was in this maximum security solitary confinement with his mental health and physical health dwindling quickly. Okay? This guy is as innocent as you or I of this crime. Okay? There's probable cause and he's been arrested, but he is presumed innocent legally. There's enough evidence to infringe on his liberty and freedom of movement, but he is innocent legally of this crime. And all of this happened to him. Just imagine if it was you and the cops think you did something years later and you don't have a good enough explanation of one specific spot you were years later. But the cops think you did it and they mother F you to death in an interrogation. They arrest you. They throw you in solitary. And this is how you're treated. In America, in Indiana, salt of the earth type of place, this is how you're treated. Now, you guys probably will not agree with me that even people convicted of crimes sometimes get treated much worse than they deserve. Some of them deserve, the worst of the worst. I get that. But we don't even have to have that discussion because we're not there when he's getting this treatment. Different than like 99% of everybody else in the same exact situation as you. And I'm not even talking about some of the disputed facts of what happened to him and some of the potential abuse and what was done to him. I'm talking about what everybody seems to agree with happened to him. And everybody that works at that jail seemed to think was okay. And actually better than how they treat some of the people there. And that to me and that's why when we talk about this, and some people can say, oh, you're just saying you don't want cameras in the courtroom because, you want to be able to watch it. Part of that's true. I do want to be able to watch it. But when you're starting to stack all these negative, un-American, not just processes and procedures on top of each other, that's when I start to look and I see it's going to be real hard for me to just be okay with this and be like, trust the system, went through the system, jury convicted him, okay. Because when you got this type of holding prior to trial when he's presumed innocent, You've got this type of an investigation where they just threw a completely reasonable theory out and then won't even let the defense argue it. When you have this type of prosecuting and police work, what wasn't done, and we didn't even do the DNA for the hair. We didn't take DNA to try to get this or that. No DNA evidence. The even just seemingly agreed upon lack of evidence, right? We got this bullet that's not great, but it's somewhat connected to Richard Allen. But we have the confession. That's our biggest piece. Then you hear all the crap in context surrounding the confession. Then you get a judge who's not allowing certain defenses, a judge who's tried to throw the defense attorneys off the case that believe in this case so much they're willing to work on it for free. They're willing to take the hate and ridicule of the public for free. And she wanted to throw them off the case. Think about Sarah Boone for a second, okay? Those attorneys were not treated properly by Sarah Boone, right? Were the attorneys perfect? Maybe, maybe not, but they weren't treated right by Sarah Boone either. And what did those attorneys want? They mutually agreed to part ways with her. Let's get off this case. We're done. Not these attorneys. They wanted to stay on the case and the judge was going to boot them off for somebody who certainly seemed like was going to be a little easier going on the prosecution than these attorneys. Then on top of that, you got gag orders. And then on top of that, you got threats made in the back rooms of courthouses to these attorneys to expose them and try to ruin their careers. You got the Supreme Court of the state saying, that's not right, get back in. You got no cameras in the courtroom. You got blocking public access to things that really seem like legally they should be viewable and accessible by the public. You've got difficult conditions because you don't want people sitting in that courtroom, especially certain people probably, sitting in that courtroom, putting a keen eye on exactly everything that's happening in Delphi, Indiana. That's going to kind of make me side-eye whatever happens in this case. It just doesn't seem right. It's not the justice system I know. I'll just say that. It's really not the justice system I know. I would hate it. And Agent Pong said, hard pill to swallow, Peter. This is very American. I mean, I would disagree, but in the courts I've practiced in, for the most part, I've never seen something like this. In a search engine type of hangman tarot card image, the one with the foot tucked behind the knee is how Abby was found. Is this how Odin did himself in the tree of knowledge? BH was 18, Libby was. Yeah, I don't know, Pesky Pirouette. I don't know these answers. The defense attorneys are public defenders. Yeah, but there were public defenders in Sarah Boone's case or private. I thought they were court-appointed private lawyers. I could be wrong. But I think they took court-appointed cases as private lawyers, so not technically public defenders. I could be wrong about that, though. I'm not positive. I agree the jury should have the opportunity to hear and consider this evidence. Thank you for covering this. And if they were, like, wouldn't it just make you feel better as a member of the public if they were able to hear this, listen to this evidence, and make their decision based on all the evidence, and then they convict him? It's like, well, they heard the other theory, they heard all the evidence, and they rejected it. It would make me feel better, more confident in the outcome of this. It appears the judge does not believe that it is better 100 guilty persons should escape than one innocent person go free, Ben Franklin. Yeah, I agree with that. I meant Logan Holder was 18 years old. Libby was 13, 14. Gosh, I don't know the specifics enough about this case, unfortunately. Libby was posed like the tarot card, the Hanged Man. The Hanged Man is Odin. Check it out. I will check it out. I will check that out. And Judge Gohl was a proponent on the trial test run for cameras in the courtroom for Indiana, yet she's got black trash bags covering all the cameras in her courtroom just for this case. I hate to hear that. I hate to hear that. I really do. I mean, it really sucks. Is there an important distinction between publicly assigned private lawyers and a public defender? So yeah, private attorneys who do public defender work, they can reject certain cases. They can say no. They can be too busy. They can come off the list if they want. Very different than a public defender assigned. You go. Now, they can't, if they reject a bunch of cases, they'll be off the court-appointed list, and you have to sign that. You'll probably accept the case that comes to you, but if you have conflicts for different reasons, there are some differences. I got to run, though, here. I'm going to answer a couple more questions. What angers me most about the trial is the corrections officers were allowed to give their opinions on Mr. Allen was faking mental illness, and the judge won't allow the defense to attack credibility. It's really, really bad stuff. Wanting justice for Libby and Abby doesn't necessarily mean that you can't also strongly believe that Richard Allen has a right to a fair and constitutional trial. Bangarang, right? Like, I mean, this is it. This is America. No matter how guilty you think somebody is, they still deserve a fair trial, a fair defense, the opportunity to present a defense if they want to. They want him to be guilty so that they can have a conviction in this case because the lack of responsible party was making the PD in town look bad. I mean, you can understand how horrible and sad this case is with these two young victims. We want justice as a community, as a nation, as a public. We want justice. Let's get justice. Let's get it the right way. Megan, I'm Norse pagan. Their body positions are Odin and Freya. Freya was also known to always be naked. So I will say I recognize the name Freya again from the Viking shows. That's my experience with it. Okay, I've got to run. I didn't realize we were already over an hour. I thought this was going to be a shorter video. But thank you guys for showing up. Please hit that like button. If you want more coverage of this case, let me know in the comments and by hitting the like button. And I'll try to do as much as I can when stuff actually comes out that I trust from the courtroom. But for this video, that's all we got. So until next time, I'm out of here. Now the outro for real. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.